the part 5, which is the modes of extinguishment of agency. Unti lang to. So, let's start with Article 1919. There are six ways or six manner to extinguish agency. The shortcut here is Edward. Okay, EDWARD. E for expiration, B for death, W for withdrawal, A for accomplishment, R for revocation, and D for dissolution. Of course, by jurisprudence, there are other ways or manner to extinguish agency. It can also be termination by mutual consent. It can be novation, loss of subject matter of the agency. Yan. In case of outbreak of war, if inconsistent with the agency. So, in case of death, okay, ordinarily, the death of the principal terminates the agency, even if a period had been stipulated and such being had not yet ended. However, under Article 1931, kindly read Article 1931, okay, anything done by the agent without the knowledge of the death of the principal. So, kung may ginawa si agent na hindi niya alam na patay na pala si principal, okay, so wala siyang knowledge na namatay ng kanyang principal or any other cause which extinguishes the agency, okay, the act is still valid and shall be fully effective with respect to third persons who may have contracted with him in good faith. So, let's just say, for example, in the case of Hermosa versus Longara, GR number L5267, October 27, 1953. Okay, in this case, let's just say Pedro authorizes the agent to support the former's grandson. Pedro subsequently died. Is the agent still required to give support? The answer there is, of course, no. Okay, for there are two reasons. One, Pedro's death terminated A's authority or the agent's authority. Also, okay, Pedro's obligation to give support being a personal, okay, it is a personal obligation. Remember in your obligations and contracts, okay, it was extinguished on his death. Next one, okay. In your Article 1920, it talks about the revocation by principal or agent. Okay? In here, the principal may revoke the agency at will and compel the agent to return the document evidencing the agency. Such revocation may be expressed or implied. Okay? In this article, 1920, it talks about revocation by principal or agency. So, what is the reason of the law of this article? Okay, in here, sabi ng batas, agency is generally revocable at the will of the principal. So, at any time, kung gustong i-revoke ni principal yung loan agency, he can do that at any time, at anywhere, okay, at any cost, okay? Because, what is the reason? Because law on agency or the contract of agency is a matter of trust and confidence. Okay? So, revocation at will is proper in two cases. Okay? Even if the agency is onerous one, okay? Or even if the period fixed has not yet expired. Okay? When agency cannot be revoked at the principal's will, meron bang instance na hindi pwedeng basta-bastang i-revoke ng principal yung contract of agency? Meron po. Okay? In the case of decided by Supreme Court, okay? 1 of Fairfield 648, this is the case of Euloyo del Rosario versus Abad and Abad. Okay? The agency cannot be revoked at will in the following instances. 1. When it is coupled with interest. Okay? interest possessed by the agent, not in the proceeds arising from the exercise of the agent, but the interest in the subject matter of the power. Another one is in cases mentioned in Article 1927, which is 1. There are 3 cases. 1. When a bilateral contract depends on the agency. 2. When the agency is the means of fulfilling an obligation already contracted. Number 3. In the case of a partner appointed manager in the contract of partnership and his removal from the management is unjustifiable. Okay. Another case is when there has been a waiver by the principal. Okay. However, the irrevocability of a power of attorney cannot affect one who is not a party thereto, it being obligatory only on the principal who created the agency. This is the case of New Manila versus Republic. So, if there is a waiver on the part of the principal, waiver not to revoke the agent, that is valid because it's already decided by the Supreme Court. Okay? However, there are some limitations. Okay? Another one is when the principal is obliged not to revoke. Here, the principal can still revoke, but he can be held liable for damages for breach of contract. Next one, okay, last, when the revocation is done in bad faith. Okay? Here, the principal can still revoke, okay, but innocent third party should not be prejudiced. Moreover, the innocent agent can be entitled to damages from him. So, can an agent recover damages? Agent cannot generally recover damages. Okay? That is the general rule. When revocation is proper, the agent cannot get damages because the principal is merely exercising a right. So, ibig sabihin nito, karapatan ng principal to revoke the contract of agency. Again, because it's a matter of trust and confidence. However, there are cases where he cannot just exercise the right to revoke, which is the 5 cases that I previously mentioned to you. Okay. Remember that revocation can be expressed or implied. Okay. Implied. Okay. Express. Paano express? It can be through writing or it can be oral. Okay. Implied, okay, as in the following manner. It can be appointment of new agent. Pag may in-appoint na bagong agent, tapos the same ang transaction na gagawin nyo or the same business, okay? Provided that there is incompatibility. So, kung in-appoint sa agent A at in-appoint, tas for some time biglang in-appoint sa agent B, it does not necessarily mean na na-revoke by implication yung contract of agency. Okay? Kung may incompatibility, yun, nagkakaroon ng revocation. Pero kung walang incompatibility, then B is just another agent of the principal. Next, if the principal directly manages the business or the transaction entrusted to the agent dealing with the third persons in a way incompatible with the agency. Kung si principal na mismo ang humawak dun sa transaction and there's also an incompatibility, then there is already an implied revocation. Next, Article 1921. This talks about the agency for contracting with a specified person. So, if the agency has been entrusted for the purpose of contracting with specified persons, its revocation shall not prejudice the latter if they were not given notice thereof. So, in this article, okay, so that innocent third parties may not be prejudiced, the principal who fails to give notification can be held liable for damages. Remember, you cannot just simply revoke an agency if there is already a transaction with another person or third persons. Why? Kasi nga hindi lang yung relationship nyo ni agent ang masisira. Okay? It can also damage your relationship with the other person or the third persons. It will cause damage on the part of the third person. So, no notice is required for persons who already know of the revocation. Yan. Sabi ng batas, hindi na kailangan ng notice dun sa mga taong meron namang knowledge na na-revoke na yung agency. Okay? Since the purpose is already been served. So, ang notice is kailangan lang yan sa mga taong wala pang knowledge na na-revoke yung agency. Next, Article 1922. This talks about when the agency when third persons are not specified. Okay. In this article, as distinguished from Article 1921, okay, the third persons have not been specified. So, hindi natin alam kung sino ang apektadong tao dito sa Article 1922. Okay? Note the effect of revocation in a newspaper of general circulation. In Article 1921, it talks about specified kasi. Yung Article 1922, it talks about not specified or unknown. So, merong third persons pero they are not known. So, sa Article 91, you will tender or give a specific notice to that person, while in Article 1922 it allows notice by newspaper by general circulation. Okay, next, Article 1923. This talks about the effect of appointment of a new agent. Okay? Appointment of a new agent revokes the first agency only in case of incompatibility. Inulit ko. Hindi porke nag-appoint lang another agent, there is already an implied revocation. Okay? Kailangan merong incompatibility. Okay, what is incompatibility? Magkaiba sila ng interest or magkaiba sila ng pag-iintindi doon sa instructions ng ating principal. Another one, okay, a special power revokes a general one. So, if agent, diba I told you before that it can be a special power of attorney or general power of attorney. So, if agent A is covered by a general power of attorney and subsequently agent B was appointed through a special power of attorney, there is already kahit walang necessarily na incompatibility, okay, if there is the so-called general power of attorney versus special power of attorney, we will consider the special power of attorney more because, as sabi sa Article 1926, the special power of attorney revokes a general one. Next one, if the first agent is not notified of the appointment of the second agent, it is understood that the first agency still exists. So, meaning, okay, pag daw si first agent ay walang knowledge or he was not notified for the new appointment of new agent, it is considered na dalawa yung agents na na-appoint. Next, Article 1924. This talks about the effect if the principal directly manages the business. Okay? So, the agency is revoked if the principal directly manages the business entrusted to the agent dealing directly with third persons. The rule applies only in case of incompatibility. Tandaan nyo yan. So, remember yung word na incompatibility. Because it may be that the only desire of the principal is for him and the agent to manage the business together. So, hindi po rin hinawakan or gumalaw na rin si principal, okay? Minanage niya na rin yung transaction. That does not it does not necessarily mean na nire-revoke na yung authority ni agent. Ang ibig sabihin lang daw nun, sabi ng batas, is the principal wants to work with the agent. Okay? However, if there is an incompatibility, then that now comes the implied revocation now comes. Okay? Article 1925, this is self-explanatory. self-explanatory. This is all about revocation by one of two or more principals. Okay, the power to revoke here is a consequence of the solidary liability of the co-principals. Okay, in Article 1926, okay, ting sinabi ko kanina, a general power of attorney is revoked by special one, okay, granted to another agent as regards to the special matter involved in the latter. So, what is the rule when special powers granted to another agent? Okay, in this article, remember that there are two agents involved. Let's just say agent A and agent B. Okay, so a specific right naturally prevails over a special one. Okay, so in that case, kung si agent B ang may special power of attorney, si agent B will now be the agent of the principal, and the agency between agent A and the principal is now revoked. Article 1927 talks about when an agency cannot be revoked. Kaya nasabi ko na kanina. Next, Article 1928 is the withdrawal of the agent. Okay, just similar with the principal. Okay, of course, the agent can also revoke the agency. Okay, so it can be by reasons of health. Okay, of course, it must be justified. Okay, so what's the effect when agent sues the principal? Anong mangyayari pag si agent bigla niyang kinasuhan si principal? Okay, when an agent files a complaint against the principal for monetary claim in the former's favor, dignity and decorum will not ordinarily permit the continuation of the agency. Such a complaint is therefore equivalent to withdrawal of the agent from the agency. This is the case of Valera versus Velasco. Article 1929 talks about the reason when a withdrawn agent must still act. Okay, the reason of this article 1929, okay, that is to prevent damage to the principal. Article 1930 talks about the agent, when can the agent continue even after the death of principal. This article, Article 1930, okay, this article speaks of an agency coupled with common interest and agency coupled with interest of third persons who has accepted the stipulation in his favor. So, for example of common interest. Zenaida borrows from Jose and as a security entrusts to Jose a ring, which Jose can sell in case of Zenaida fails to pay the debt at the time of maturity. Even if Zenaida dies, the agency of Jose would still remain. Okay? In case of agency of interest of a third person naman. Example, Melody sells her land to Bravo and appoints Bravo her agent in paying with the purchase price what Melody owes Arellano, a third person. Here, even when Melody dies, the agency of Bravo continues to exist. Last and next article, 1931. Okay, this talks about the effect of agents act without knowledge of the termination of the agency. Note that the law here requires the third persons to be in good faith. If in bad faith, they cannot be protected. So the rule in case business was already begun, okay, under the second paragraph of Article 1884, the agent must also finish the business already begun on the death of the principal should delay entail any danger. Last article, Article 1932. If the agent dies, his heir must notify the principal, and in the meantime adopt measures as the circumstances may demand in the interest of the latter. In here, what is the effect of the death of the agent? If the heirs of the dead agent are unable to give notice, pag hindi daw nakapagbigay ng notice yung mga naiwan ng agent na namatay, okay, one good measure for them is to consign the object or property of the agency in court. So, kung di sila makapagbigay ng notice sa principal, they should consign or they should give or surrender the property sa ating honorable court. In this way, they can still protect the interests of the principal who entrusted their predecessor in interest. The heir's duty arises from what may be termed as presumed agency or tacit agency or an agency by operation of law. So, question. In an agency coupled with interest, does death of the agency terminate the agency? The answer. Generally, the agent's death ends the agency, for it should not be continued by one upon whom the principal has reposed no confidence. Okay? But under American law, when the agency is coupled with interest, it has been held that agent's death does not terminate the agency. Such a power may be subsequently exercised by a personal representative, at least insofar as may be essential to protect the interests of the estate of the agent. So that ends the discussion for law on agency.